it never appeared on the asset side of Justice Corona, the respondent.
Yes, Your Honor. It never appeared for the payments of 2003. There was no entry as to the payments that were made, as well as to the payments that were made in 2004. Your Honor.
In 2005, did the cash payment of 3.5 million appear?
No, Your Honor.
In a SAL of 2006, did the 3.5 million pesos appear?
Not also, Your Honor.
In 2007, did the 3.5 million appear?
No, Your Honor.
In 2008, did the 3.5 million appear?
No, Your Honor.
In 2009,
No, Your Honor.
so it finally appeared in 2010.
Yes, Your Honor.
Now, in double entry accounting, asset equals liabilities plus net worth. In fact, the Constitution is really based on the principles of double entry accounting. So therefore, if you take something out of your asset side, you have to replace it with another asset or with a liability.
Yes.
Now,
that's
in
correct.
this particular case, how did the respondent book an asset in the amount of 3.5 million? Is there anywhere in his SAL that reflected that?
Based on the evidence that we have presented, Your Honor, for the SAL-N for the years 2003 to 2009, there were no entries made by the respondent, Your Honor.
And lo and behold, it appears in 2010.
Yes, Your Honor. And our position is that, Your Honor, even under accounting rules, an entry should have been made when payments were made, and the entry should have been an investment in real property. Or it may be even an other asset, Your Honor, but no entries were made during the
Or
years.
if there was an objection or a question, maybe an accounts receivable from Ayala Land or Alveo Land.
I agree, Your Honor. That is correct.
Thank you very much,
Thank you.
Mr. President.
All right. Counsel?
Mr. President, I would like to thank counsel for his testimony. Anyway, yesterday, Mr. President, you
I'd
mentioned...
like to object to that, Your Honor.
Withdrawn, Your Honor.
Avoid this.
May we request that that be stricken out, Your Honor, from the record?
I withdraw. My apologies, Your Honor.
Strike it out. Of the,
Thank you, Your Honor.
that was a narration of the lawyer based on his recollection of the facts.
I see now, Your Honor.
Not under oath anyway. So.
Mr. President, yesterday you asked me if this was to be treated as an asset. Oh, by the way, may we ask that Mr. Lim be discharged, Your Honor?
The witness is discharged.
Thank you, Your Honor.
Mr. Lim, you can go.
Oh, I'm sorry.
President, before we discharge the witness, may we recognize Senator Miriam Defensor Santiago?
All right. You stay in on the witness stand because the lady senator from Iloilo wishes to ask a question.
Thank you. I would like to raise a question not only with this witness but also with both counsel. Mr. Witness, what is the provision of the master deed for the Columns condominium units with respect to the transfer of ownership?
For that, Your Honor, I don't have an idea.
You don't know when ownership is transferred?
For the ownership, ma'am, I don't have an idea. But for the acceptance of unit, yes, Your Honor.
All right. What is the provision of the master deed on the acceptance of unit?
Once the unit owner accept the unit, Your Honor, that's the only time that we will charge the association dues.
Under the language of the master deed, what is the meaning of accept? Do you have any idea?
That's the time, Your Honor, that the unit owner really accepted the unit.
Think
I mean,
again. What do you mean by accept? He accepted verbally? He accepted physically? He accepted in writing? What is the meaning of accept?
Based on my observation, Your Honor.
Your observation?
Yes, Your Honor, that there is a form on there, but that is already for the developer side, Your Honor.
Obviously, you're not very familiar with the legal aspects of the transfer of ownership over the condominium unit.
Yes, Your Honor.
Yes. Now, our issue here is, when should the condominium unit in the columns have been declared in the SALN of the defendant? That is our issue here. To be able to answer that issue, we have to know when did he become the owner. Now there are two contending sides and they have different positions. According to the prosecution, the defendant became owner when the certificate of title was issued to him. At that point, apparently, your corporation took the position that the unit was deemed accepted. Is that the language you use?
For the corporation, Your Honor, when I present the master release, it was stated that August 2009, Your Honor, that the unit accepted.
Is deemed accepted when the transfer certificate of title is transferred to the buyer. Is that your practice there in your corporation?
It was accepted, Your Honor. Accepted.
Toto, there are so many methods of acceptance in law. So, what I'm saying is, under your master deed, apparently your corporation has laid down the rule that once the transfer certificate of title has been issued to the owner and accepted by him, then he's deemed to have accepted the condominium unit. You don't need to, that is not a question, but that is apparently the position of your corporation. But on the other hand, the position of the defense is that ownership was not transferred upon acceptance of the transfer certificate of title, but was transferred only when the buyer took full possession. So there are two contradictory views of when ownership was transferred, and therefore also two contradictory views on when the property should have been declared in the SALN. What year? Transfer of title was made in 2004, but apparently declaration was made only in 2009. That is our issue today. Now, I'm going to raise this question with the prosecuting counsel. Counsel, in view of this issue, I will quote to you a decision of the Philippine Supreme Court in Cebu, Winland v. Ong Xiao, which was promulgated in 2009. In effect, in this case, the Supreme Court held that symbolic or presumptive delivery, which seems to have taken place and which seems to be the anchor for the argumentation of the prosecution. Apparently, just to summarize, prosecution takes the position that once transfer certificate of title was accepted by the buyer, that was presumptive or that was symbolic delivery. And since delivery has already been accomplished, then he was the owner as of that date. That is your position. Isn't that so?
Yes, Your Honor, and that
Yes.
is also provided for in the contract to sell, Your Honor,
All
of the
right.
particular unit.
Okay. But in the case of Cebu Winland, which was promulgated in 2009 by the Supreme Court, the court held that symbolic or presumptive delivery by the execution of public instrument, meaning to say the transfer certificate of title. And here I will emphasize what the court said, can be negated by the failure of the vendee to take actual possession of the land sold. What do you say, counsel?
Your
that
Honor, we have
passage in
cited,
this case.
we have submitted to the court a memorandum regarding this issue, and we also cited, Your Honor, the case of Marcela versus Court of Appeals.
What case
It
was
was-
that? When was that case promulgated?
It was decided, Your Honor, in March 27 and 2007.
That was 2007. This is
Yes, Your Honor.
2009.
And the facts of the case, Your Honor,
No,
And-
excuse me. Let's stay with this particular point. You are citing to the court a 2007 case. The court is citing to you a 2009 case and is asking you to comment on this provision from the Supreme Court case. We are familiar with the rule that the latest case controls.
we have also cited a 2010 decision, Your Honor,
All right. What case was that?
in the case of Raimundo S. De Leon versus Benita T. Ong. Supreme Court said, Your Honor, that under Article 1498 of the Civil Code, the execution of a notarized deed of sale is equivalent to the delivery of the thing sold.
That is a general rule, isn't
Yes,
that so? So you're just citing a general rule. Here in Winland, Supreme Court is citing a specific rule, and you know that specific prevails over general. Now, you're citing this 2010 case. Let me ask you this question. Did it involve a condominium unit? If you are not sure, you may say so.
I am not sure, Your Honor.
All right. Now, in this Cebu Winland, on which I rely very strongly because it is the latest case, I have to quote extensively from the Supreme Court. I'm quoting now. Article 1497 of the Civil Code contemplates what is known as real or actual delivery when the thing is sold in the control and possession of the vendee. On the other hand, Article 1498 refers to symbolic delivery by the execution of a public instrument. It should be noted, however, that Article 1498 does not say that the execution of the deed provides a conclusive presumption of the delivery or possession. It confines itself to providing that the execution is equivalent to delivery, which means that the presumption can be rebutted by means of clear and convincing evidence. Now, my question to you is, since there is no conclusive presumption, you're only relying on a preliminary presumption that can be overturned by clear and convincing evidence. Isn't that so?
Yes, Your Honor.
Yes, that is your position. I don't think I have... well, let me just ask, for asking sake, the defense counsel. Counsel, what is your position? Did Chief Justice actually accept the unit?
Your Honor, may I draw your attention to paragraph 7.2 of the contract to sell. Specifically, the second half of the paragraph, I will dispense with reading the first part, but the second half which says, if rectifications or adjustments are made in the unit, the seller shall, upon completion of such works, notify the purchaser of the readiness of the unit for final inspection, and the purchaser shall have 15 calendar days from receipt of such notice of final inspection to inspect the unit together with the seller for the purpose of determining whether the necessary rectifications or adjustments requested by the purchaser in connection with the first inspection have been made. In other words, Your Honor, there is a process by which acceptance must be conducted. If there are issues raised, there is a process of consultation and verification in terms of the works being done, in terms of the gripes of the purchaser, before the acceptance is made. Now, we are all familiar with the concept of a deemed acceptance. But when we speak of a deemed acceptance, that is merely a declaration of the seller. It is not perforce a voluntary recognition of the buyer that the unit has been received in good order. That is the issue in this case, Your Honor.
You're raising the argument that the phrase deemed acceptance is unilateral on the part of the condominium seller.
Precisely, Your
Agree
Honor,
that?
because a deemed acceptance indicates that there has been no acceptance by the buyer.
Counsel for the prosecution?
Your Honor, our answer to that is the applicable rule, Your Honor, is 7.3 of the contract to sell, which came later than 7.2, which is read by esteemed counsel of the defense, Your Honor. And if I may be allowed, Your Honor, 7.3 states, the seller shall be deemed to have delivered the unit and the purchaser shall be deemed to have accepted the unit upon the earlier in any of the following dates, Your Honor. And there are three. The date of final inspection, or if the purchaser fails to inspect the unit within 15 calendar days from receipt of the final notice of inspection. Letter B, the date of possession by the purchaser of the unit. Letter C, the date of execution by the purchaser of the acceptance form. And letter D, and this is where we are relying, Your Honor, is the date of execution of the deed of absolute sale. So when the deed of absolute sale was executed, Your Honor, the prosecution is of the position that delivery was made. And in the case that I cited, Your Honor, a while ago in Marcella versus Court of Appeals, Supreme Court said that it is of no legal consequence that petitioner did not take actual possession or occupation of the disputed property after the execution of the deed of sale in her favor because she was already able to perfect and complete her ownership of and title over the subject property. So that is the prosecution's